Yeah, to mention item number 3, Your Lordship. National Council Mr. M.A. is saying to can't go due to some medical condition, Your Lordship. Maybe taken up in the next week, Your Lordship.
Which is represented on the prayer made by and profit to the Christians. John today, this video did after the week. Yes, next.
May it please your lordship. My senior, Mr. Arguswamy's son has expired and he is on leave. I have taken consent from the petitioner. We are for the respondent New India. Lordship kindly adjourn the matter for 3 weeks.
Which item?
16.
Lordship, I am appearing for the appellants in this case. 15.
16.
15.
16.
Who is expired?
Mr. Arguswamy's son has expired and he is on leave.
Which is a representative on the prayer made by the council for the respondent. The magistrate is drawn today. List after.
D. Goswami on behalf of Arguswamy. After 3 weeks. Deeply obliged.
May it please Your Lordship. Your Lordship, I beg to mention item number 7. I'm mentioning on behalf of Amicus Curie, Your Lordship. She is not available today. Yesterday, we tried to submit adjournment note, Your Lordship, as the matter is of 2017, so we could not take the signature. Okay.
Item 7, which is represented in the prayer made on behalf of the Leonard Amicus Curie to Magistrate General today. List on. Give a date. We'll take it up on Friday.
Your Lordship, it can be fixed on 13. I have instructions. It can be fixed on 13, Your Lordship. 1-3. Thursday.
Repeat.
Lordship.
88.
1-8. Deeply obliged.
Yes, Lordship. Yesterday, I have submitted a slave regarding item number 1, Lordship. Actually, in this case, my senior's presence is required. Now he is hospitalized in Kolkata.
Is it?
Currently, adjourned for 2 weeks.
What has been diagnosed now?
Lordship,
What has been diagnosed now? In Calcutta?
heart problem. So, suffering from a cardio problem.
Which is represented on the prayer made by Mr. James Suleiman and counsel for the petitioner. The matter stands adjourned today. List after?
2 weeks. 2 weeks. 2 weeks.
Okay, give a date after 2 weeks.
So another matter, Lordship, can be called motion matter, Lordship. I have called another matter is called listing of a motion.
Yes, sir.
Make please, Your Lordship. My Lord, I beg to mention item number 2, my Lord.
2.
My Lord, I am newly engaged, my Lord, in this case. So, my Lord, it may be taken day after tomorrow, my Lord.
Okay. List on 6/8/2026. We said both sides are represented. List on 6/8/2026 as paid for by Mr. M.A. Sheikh and counsel for the petition.
Provisions.
For orders, item 4.
there are some developments. Yesterday, there was a meeting. Yesterday, there was a meeting of the chairman, member secretary, the appellants, and as well as the respondent number 7. Now, also, there are 7 vacancies. Now, they have decided to promote as per seniority of the gradation list, which I have annexed in my interlocutor documentation. From serial number, you will find at page 20 of my IA. From serial number 21 to 27. We have decided to promote, but that instruction will have to come from the pollution control board also. So, may I pray, the matter be
You
on Thursday?
you appear to be better placed than Mr. Bain or the government.
But here, Mr. S. Brewer will appear on behalf of the Pollution Control Board. Mr. S. Brewer will appear on behalf of the Pollution Control Board. But in fact, yesterday there was a meeting, that is a review meeting. Only thing, the instructions are awaited from the authorities. If your lordship thinks the matter day after tomorrow.
Mr. S.K. Das, learned counsel for the petitioner, and Mr. R. Day, learned counsel for the respondent number 7 are present. There is no representation from the state pollution control board. And Forest and Environment Department. Next one. The learned counsel for the you could be applicant, huh? The learned counsel for the applicant and the respondent number 7 have submitted that certain developments have taken place and therefore they pay for adjournment. Here is allowed. Next one, list on 6/8/2026.
Forest department.
Yes, what is your instructions?
Lordship, they are not the necessary party of the main party. They are not the main party here. Political
Forest department is present.
Lordship, the interim order may kindly be extended.
Interim order of fast release stands extended to the next date of this day.
Obliged.
Item 6 for orders.
May please.
Yes.
IA, my lord. Annexer A. Annexer B, my lord, is. You may kindly look at this. Page number 12, my lord. May I read, my lord? I have normally verified the national list of Nazrul Haq, son of Ashad Ali of village Pangrirsor, PS South Salmara district, Dhubri, and for his grandfather, namely Thuban Sheikh, appeared in the electoral roll 1966, 31 Mankasor LSC, part number so-and-so of village so-and-so, PS South Salmara subdivision, Dhubri, district Goalpara, height serial number so-and-so, house number so-and-so, and also he produced relationship certificate of his grandfather issued by the secretary of Maliralga GP, dated so-and-so, CS circle, CS by CO Mankasor, dated so-and-so. Now it is seen that he is not an IM or foreigner.
page 18, Lordship.
Yes, Mr. Sharma.
Lordship, page 18 and 19, Lordship. They approached the Supreme Court after by challenging the High Court's order, and Supreme Court observed, Lordship, in spite of inordinate delay of 3575 days and 3173 days in filing the special leave petitions, we have heard the learned counsel for the petitioner on merits in view of the categorical finding that petitioner relied upon forced birth certificate on account of which he is also facing criminal trial. We see no reason to entertain the special leave petitions. However, learned counsel for the petitioner at this stage seeks and
and is permitted to withdraw the special leave petition as according to him, he would file a review petition before the High Court based on certain new sets of documents. Without expressing any opinion in relation thereto, the special leave petitions are dismissed. Your Lordship, I think Lordship may not entertain this petition and it may be dismissed in limine. Lordship.
No, he's now relying on that note by someone.
Lordship,
He is now relying on a note by someone that he is not a foreigner. What do you say? That
Yes, 13.
Hmm?
13. SPL 13.
no, very good. All these things are, my lord, already before the concerned tribunal and also after that lordship tribunal, after seeing everything, tribunal has passed the opinion and lordship after verifying all these things, Honorable High Court come to the conclusion that petitioner is an illegal migrant, lordship, and apart from that, he approached the Supreme Court, lordship. There also he failed to establish his citizenship, lordship, and another aspect, lordship, he relied upon forced birth certificate, lordship, and lawyers already settled, lordship, fraud, vitiate, everything, lordship. Grounds with you, High Court or High Court.
Mr. Sharma, few months back,
Lordship,
we had passed an order on that reference by ERO. You remember the
yes, Lordship.
order?
Yes. In respect of ERO's reference, Lordship.
Reference of ERO. We passed a.
WPC 245 of 2019, Lordship.
Hmm?
Yes. WPC 245 of 2019.
WPC 245, just check out. WPC 245, 2019.
Tukurjan Nesa. 245, 2019. It is reported, Lordship.
Reported.
Yes, Lordship. Two 2 GLT 1058.
2025,
2 GLT 1058.
to GLT 1058.
Lordship.
You're not getting it. 1058.
Lordship. Just a minute.
2025.
1058. 2025 2 GLT 1058.
Yes, but yes, go down. Scroll down. Yes, yes. No, come down. Up to 4 pages. Yes, come down. Yes. On the-
Samuddin's case was reaffirmed by this judgment. Lord. Samuddin's case was reaffirmed, Lord.
Samuddin.
Yes, Lord.
Yes, come down. Okay. Now we are not getting it in the that
Lordship,
2025 to GLP
yes, Lordship.
1058.
2025 to GLT 1058.
Yes. Top of the title. Okay, I got it. Yes, anything more you have to say?
Yes, my lord. My lord, it is second review petition, my lord. On the repetition 3660 public 2015. Earlier the repetition, it was dismissed on the fact birth certificate, my lord. In that regards, one PRC case has been registered, my lord. But I have applied for the details record, my lord, but till date I have not, the learned CGM, South Salman Mangasar has not been furnished, my lord. Copy of application I have annexed in the review petition, says 169, my lord. On 70, copy of application. Thereafter, the review petition has been filed, my lord. The same was dismissed on the fact birth certificate, not on the case merit, my lord. Thereafter, the petitioner approached before the Honorable Supreme Court. Supreme Court has given liberty to file fresh review application before the High Court, my lord, which is annexed in IA Annexer B, my lord, page 18. So now I am relied upon the case diary and the police report, my lord. Now, another new sets of documents, my lord. Earlier, this was not placed before this honorable court, my lord. CD police report, and final Kotian 1962. And subsequently, the petitioner mothers has declared Indian my lord, which was annexed my lord in the review petition, as well as the IA also my lord. Annexer 3 my lord, page 14. Nurjahan Baba is the mother of the petitioner, my lord. My lord, sorry, my lord.
Please, the copy to the cover.
You're saying that you're relying on the CD, no?
Yes, my lord.
How did you get a copy of the CD?
This was like furnished by the learned tribunal, my lord. This was earlier not submitted before this honorable court due to some inconvenience. Because he
But can you give me a tribunal, furnished copy of the CD?
CD was in the file, my lord. The petitioner's wife is a layman. She cannot she
No.
cannot tell, my lord.
No, can a tribunal furnish copy of the CD to the parties?
Yes, my lord.
I don't think so.
This CD was in the file of the husband of the petitioner, my lord. Page 11 also there, my lord. In the IA, my lord. Page 10. Page 10, my lord. Page 10. District DBB reference case number 20, serial number 1023, house number so and so, dated so and so. CD number 1. GD entry number 1. Now I have made a GD entry for aforesaid nationality verification. GD number 2. Now I filed up the form, that is annexer A, annexer B under rule 9A on the basis of verification report and submitted before the Honorable SP DBB. GD entry number 3. Now I, Girindranath Deka, yes, I close the GD. I submission, my lord. This matter may kindly heart on merit, my lord. In the year of 2015, the petitioner was arrested, and 2019 he was released on the strength of Supreme Court suo motu case order. Thereafter, subsequently, he has arrested again 25th May 2025. Still he is in custody, my lord.
Second reviewability হবে, হ্যাঁ। Oh. Single document review. Hello, this is second review document.
Yes, yes. What do you say regarding the reference made? The reference was made by the electoral registration officer What do you have to say on that?
The Lordship, reference has been made by the ERO South Mankasor LSC in gross violation of section 8 and 8A of the illegal migrant IMDT Act, my lord. Rule 8 and 9 of the illegal migrant rules, my lord.
Yes.
Police report says, my lord, I have submitted the documents. Case diary, part of the case diary, my lord. I have submitted the documents wherein mentioned it is seen that he is not an illegal or foreigner. But the ERO has forwarded the case to the SP border Dhubri, my lord.
Okay.
Now I want to relate upon this police report and my humble request, my lord, may kindly heart on merit.
We are
Now,
hearing you on merit.
my lord,
We are hearing you on merit.
there are
Otherwise, we will not
some,
have spent 45 minutes here.
my lord, there are some new sets of documents
Which document are you?
in review petition, my lord. Final quotidian.
Page, give us page.
Yes, my lord. Final quotidian dated 18/1/1962,
Page.
89, my lord. Page 89. Wherein the grandfather of the petitioner name has been appeared, Abdus Soban, along with other siblings of the grandfather, my lord. Thereafter, Botalist 1970, my lord. Page 94. Type copy, my lord, 93. Abdus Soban, son of Duran, my lord. 70. 93, my lord. Then, my lord, page 95. Soban Sheikh, son of Duran Sheikh. Mother name has been appeared along with my grandfather, Nurjan Bawa. Then, my lord, page 97, Soban Bepari, along with my mother. Name has been appeared, my lord. Page 97. Then, my lord, page 99. Nurjahan Bawa, along with my name, 97. Then, my lord, my mother has been declared as an Indian. My link is established in the voter list 1997. And also one Kasapatta also there, my lord, in the case paper. Page 41. Number 1, Nazrul Haq. Number 2, Shukur Ali, son of late Muhammad Asad Ali. Number 3, Musammat Nurjahan Bawa, wife of late Asad Ali.
Yes, please continue. Don't stop. Please continue.
So, my lord, Kasapatta and the voter list 1997 is the linkage document. So, my lord, my mother is an Indian. So, I am the son of my mother. As such, I am also citizen of India.
Under which law you follow the matrimonial lineage? Matrimonial lineage, how do you follow that? Under which law?
Yes, sir.
Which page is your Kachapata?
But at page 41, my lord.
But your name?
K. Islam.
Mr. K. Islam, and counsel for the applicant and so also for the respondents. By filing this interlocutory application on the applicant, who is the petitioner in the connected review petition number 113 of the 2026, has claimed for condemning the delay of 3675 days and 3270 days respectively in filing the connected review petition. Next one. The petitioner was a proceeding in FT case number 530/SSM of the 2010. Was instituted before, which was registered before the learned Foreigners Tribunal at Dublin, Foreigners Tribunal number 1 at Dublin, by an opinion dated 1/2/2011, where the petitioner was declared to be an illegal migrant who had entered India without valid documents subsequent to 25/3/1971. The said opinion was unsuccessfully assailed by filing a writ petition in Article 226 of the Constitution of India, which was registered as WPC 3660 of 2015. And this court, by an order dated 22/6/2015, had examined the matter on merit and dismissed the writ petition. By an order dated 29/7/2015. Amongst others, on the ground that the birth certificate relied upon by the petitioner was found to be fake birth certificate. No. It is not 29/7/15, but it is by order dated 30/11/2015. Full stop. Thereafter, the petitioner had filed, the applicant had filed a review petition, which was registered as review petition 73 of 2016. And this court, by an order dated 5/1/2017, dismissed the review petition. Full stop. Next paragraph. Thereafter, on the ground that the petitioner has some additional documents on which reliance was placed, the petitioner had assailed the judgment and order dated 5/1/2017 in review petition number 73 of 2016 and judgment and order dated 30/11/2015 passed in WBC 3660 of 2015 before the Supreme Court of India. Whether it was registered as special leave petition within bracket civil bracket close diary number within bracket S bracket close full stop 72150/2025, page 167. And the Supreme Court of India by an order dated 16/3/2026. While finding no reason to entertain this special leave petition, however, granted leave to the petitioner to withdraw the special leave petition to enable the petitioner to file a review petition before this court. Full stop. The Supreme Court of India, without expressing any opinion in relation thereto, dismiss the petition on withdrawal with dismiss the petition on withdrawal. Next paragraph. Therefore, in deference to the said order dated 16/3/2026, passed by the Supreme Court of India in special leave petition within bracket civil, bracket 2 diary numbers 72150/2025, court has heard the learned counsel for the applicant on merit of the connected review petition. Upon just leave a gap there, okay? Upon so. Next paragraph. In in this review, in the connected review petition, the case of the petitioner is that he the that on 28/4/1998, a GD entry was made on the basis of information regarding the nationality of the petitioner and in the and as per the police report contained against case diary number 1, dated 28/4/1998, the police report to the Superintendent of Police contained a remark that the petitioner is not an illegal migrant or foreigner. Full stop. It is projected that the LVO report LVO within bracket, local verification officer bracket was report was not filled up except the name of the petitioner, name of the village and name of the father at column number 1, 2 and 3, and that column number 4 to 16 were not filled up. And accordingly, it is projected that no verification was carried out and the reference was made without any verification or recording of satisfaction or by providing opportunity of hearing to the petitioner. Full stop. Next, the learned counsel for the petitioner has further submitted that the said fact could not be brought, could not be agitated in the earlier occasion. That's right. Next, it is further submitted that the petitioner has found a kachapata. Which page is that kachapata?
41, my lord. In review petition.
Found a kachapata in reflecting the names of who are they? Nazrul Haq, Shukur Ali, Musammat Nur Jahan. Who are they?
Nazrul Haq is the petitioner, my lord. Shukur Ali is the brother of the petitioner.
Okay.
Musammat Nurjahan Bewa is the mother.
Okay. Containing the name of the petitioner, his projected brother and projected mother. So accordingly, it is submitted that the petitioner can be linked with his projected parents on the basis of the same. Moreover, it is submitted that the projected mother of the petitioner, namely Nur Jahan Bewa, has been declared to be not a foreigner by opinion dated 27/9/2018, passed by the learned member, Forest Travel 3rd Dhruvi, Hatsingi Mari, in FT case number 346/2018, arising out of reference with page 163, reference FT 1/2, case number 1171/SSM/11. So next it is submitted that the though belatedly, the petitioner had approached the Supreme Court of India and the said honorable court by I passed the hearing before if I ordered the 16/3/2026. Yes, we have covered everything. We have covered everything.
Yes, my lord.
Okay. Next para. Per contra, the learned study counsel for the border and FT matters has opposed the prayer in view of the inordinate delay and has not only opposed the prayer for continuing the delay, but also made its submissions in support of the impugned opinion, as well as the order of the court which is under review. Next para. Are you relying on any judgments?
No,
Yes, Mr. Mandal, you can come over.
we are basically the lordship has already seen the case diary where it is stated that I am not an illegal migrant. That is the only source where from we can get any relief. That is it. Not a legal migrant.
From the contents of the opinion dated 1/2/2011 passed by the Learned Foreigners Tribunal, comma, it has been mentioned that the case was originally forwarded under IM within bracket D bracket plus T Act, is second bracket, and then say illegal migrants within bracket determination determination by tribunals bracket close Act, comma 1983.
Not
83 or 85? 83. Provide reference case number 1599/98 forwarded by the Superintendent of Police within bracket, sorry, Superintendent of Police, comma, Dhuvi, comma, doubting his nationality. Full stop. The entire set of the reference so made by the Superintendent of Police within bracket border bracket was Dhuvi is not available in this in the connected review petition. And it appears that selective documents have been annexed in the review petition. Full stop. Though the review petition contains the format for verification officer's report within bracket annexure A and form Roman 7, comma, but the direction by the electoral registration officer of sorry, for 21 Mankachar SMD constituency is not available. And moreover, the form of reference to the form while is the reference was forwarded to the Superintendent of Police border Dhubi is not found available. First of all, as per the Contents of annexure A format for verification officer's report, comma, at page 1 and page 3 thereof, it has been reflected that no documents produced. Full stop. Except for column 1, 2, and 3, comma, all other column numbers 4, CO2, 16 are blank. Full stop. In form number 7, Roman 7, comma, the against column number 11, comma, the Superintendent of Police Superintendent of Police Dhubri has made a comment that made a comment against against the grounds for having reasonable doubts that the person concerned is an illegal migrant, comma, the remark by the Superintendent of Police Border Dhubri is, invert commas, no document produced, invert full stop, bracket closed, invert comma closed. Next paragraph. As per the submissions made by the learned Standing Council for the Border and Active Matters, comma, this being a case referred by the electoral registration officer, comma, the decision of this court in the case of Sayam Uddin, SAYAM, next word Uddin, UDDI, versus Union of India and others, comma, 2019, bracket close, within bracket 4, bracket close GLT, 456, comma, as affirmed by the division bench in the case of Sayam Uddin versus Union of India and others, comma, WA 170/2019, comma, decided on 29/7/2019, which was followed by this court in the case of Shukurjan, SHUKURJAN, next word Nessa, NESSA, alias Shukurjan, SUKURJAN versus Union of India and others, comma, uh, 2025, column, GAU-AS, column, 2045, equivalent to uh, 2025 within bracket 2, bracket GLT 1058. would apply. Next paragraph. In the cases referred above, comma, it has been observed that that under the central government notification dated, the notifications dated 19/4/1958 and 17/2/1976, comma, the government of Assam, comma, superintendents of police and deputy commissioners within bracket in charge of police, bracket close, have been delegated the power to make reference to the foreigners tribunal under order 2 within bracket 1, bracket close of the foreigners within bracket tribunals, bracket close order, comma, 1964, to seek an opinion as to whether the proceeding is a foreigner or not within the meaning of the Foreigners Act, comma, 1946. Full stop. In the present case in hand, comma, from the documents annexed in the connected review petition, comma, the reference being made on by the Superintendent of Police, comma, Dhubri, on 31/7/1998 would be a reference under under section 8 of the IM within bracket B, bracket goes T Act. The registration of the reference under section 8 within bracket 1 of the IMDT Act is reflected in the order dated 3/2/2000, passed by the then illegal migrants within bracket determination, bracket is tribunal, comma, Dhubri, in IM within bracket D, bracket goes T, case number 15354/D/2000. Full stop. Thus, comma, it is evident that evident from the above that the electoral registration officer, comma, (21) Mankasar LAC having doubted the petitioner as a voter had made the reference. Full stop. It would be appropriate to mention that on upon questioning of the said illegal migrants within bracket determination by tribunals, bracket Act, comma, 1983, by the Supreme Court of India in the case of Sarvanan Sonwar versus Union of India, comma, 2005, 5 SCC 665, comma, all references which were pending before the erstwhile IMDTs stood transferred to the jurisdictional foreigners tribunals. Full stop. Therefore, comma, as those proceedings were transferred by virtue of orders passed by the Supreme Court of India, comma, it would not be open to this court to make any comment on the reference being so transferred. Full stop. Next call. As indicated herein before, by virtue of the notifications, two notifications dated 19/4/1958 and 17/2/1976, the Superintendent of Police are the designated authority to submit reference. And the doubt by the electoral registration officer is an exercise which the electoral registration officer has the power under the Representation of the People Act, 1950, the Election Commission of India is, not being the authority to investigate into the citizenship, can only refer the matter to the Foreigners Tribunal for an opinion as to whether or not the doubtful person is or not a citizen of India. Full stop. Next, it may further be stated that the local verification officers appointed by the electoral registration officer are those persons whose services are requisitioned by the Election Commission of India for election duty, and therefore they are not police officers doing regular crime inquiry. Full stop. Therefore, comma, in this regard, the court places reliance on paragraph 26 of the case of Sarvanan Sonwar within bracket Supra, where the Supreme Court of India has observed as under. Next paragraph. Insofar as the electoral registration officer is concerned, the exercise undertaken by him or her while marking a person as a inverted commas D voter in the electoral roll is a quasi judicial exercise. If the said authority holds the view after examining the inquiry report of the local verification officer that the concerned person is not a citizen of India, he is required to forward the case to that the case of that person to the competent authority, i.e. the Superintendent of Police. Full stop. Therefore, the jurisdictional Superintendent of Police has to make a reference to the competent foreigners tribunal under Order 2 within bracket 1 of the foreigners within bracket tribunals bracket close order, 1964, based on the report received from the electoral registration officer. Full stop. Therefore, question of making further inquiry by the Superintendent of Police in such a case would not arise because inquiry has already been made by the electoral registration officer by exercising quasi judicial powers. And the Superintendent of Police cannot sit over such decision of the electoral registration officer. So hence, he has to forward the same by making the reference to the competent foreigners tribunal for its opinion. First off, this issue has elaborately been dealt with in the case of Sayamuddin Supra, and Tukurjan Mesa within bracket Supra. Next one. The learned counsel for the petitioner had referred to the remark made in the case diary that the petitioner is not a illegal migrant or foreigner. Is of no consequence because the Superintendent of Police within bracket order Dhuri did make a reference before the foreigners tribunal, before the erstwhile illegal migrants within bracket determination bracket coast tribunal, and thereafter the matter was transferred to the foreigners tribunals to stop. So it may be clarified that the present inquiry against the petitioner is not found to be initiated under the Foreigners Act 1946, but as reference can only be made under the Foreigners Act 1946, the initiation was done by the electoral registration officer. Next one. It is in the said context that the Supreme Court of India in the paragraph 26 of the case of Sarvanan Sonwar within bracket Supra, which is abstracted herein above, was made by the Supreme Court of India. To stop. Next one. Insofar as the Hatiyan and the Tachapata referred by the Legal Counsel for the petitioner is concerned, the documents annexed to this review application indicates that the Kachapata was duly discussed by the learned foreigners tribunal in the opinion dated 1/2/2011. In paragraph 7 of the said opinion. Full stop. The learned counsel for the petitioner has referred to a new document, which is the Khatian. Where is that Khatian? Which page?
Page 89.
89. Which is purportedly issued on 18/1/1962. And the learned counsel for the petitioner projects that the same contains the entry of one Abdul Shoban, ABDUL SOBAHAN, who is projected to be the grandfather of the petitioner. This one. In in paragraph 9 of the written statement of the petitioner, filed before the foreigners tribunal, the petitioner has disclosed that his grandfather's, the name of grandfather of the petitioner is Abdul ABDUL Sobhan SOBAHAN Sheikh SK, alias Sobhan Sheikh SK. Whereas and as indicated above, the Khatian contains the name of Abdul Shobhan. Therefore, at this stage, when the court is examining a review petition, it is not for this court in extension of the certiorari jurisdiction to examine the documents and to form an opinion as to whether Abdul Shobhan, whose name appears in the said Kachapata, is the same person referred to in paragraph 9 of the written statement, namely Abdul Shobhan Sheikh, alias Shobhan Sheikh. Full stop. Moreover, the petitioner has not been able to satisfy the court as to why, despite due diligence, the same could not be produced before the foreigners tribunals, and also not brought to the notice of the court in the proceedings of WPC 3660/2015.
Next one. Accordingly, his only 2 points have been urged by the Land Council for the petitioner. First, relating to the form of verification officer's report and the observations made in the case diary. And the second being the land documents, which have, and both have been addressed in this review petition, in this order. Stop. No other point has been urged by the Land Council for the petitioner. Accordingly, as stated above, in deference to the order passed, order dated 16/3/2026, passed by the Supreme Court of India in SLP Civil Diary numbers 72150/2025. The matter has been examined on merit. Next paragraph. Be that as it may, having not found any merit in the review petition, the same is dismissed. Next paragraph, before parting with the records. It required to be stated that this review petition was the second review petition filed by the petitioner, and the first review petition was dismissed by this court by order dated 5/1/2017, passed in review petition 73 of 2016. Next paragraph. This court, in the case of so and so, passed an order along with Justice Manish Chaudhary. You remember that?
But
Few days back only we passed an order.
But
Second
in
review.
Lily Thomas case, Lordship, para 56, Lordship, it was said that once a review petition is dismissed, Lordship, no further review petition can be
Please
entered.
cite that name.
2006 SCC 224,
2000
6 SCC
224.
224, Lily Thomas and others.
Oh, Lily Thomas.
Yes, yes, Lordship. Para 56.
Para
56.
56. So in this regard, reference can be made to the finding of the Supreme Court of India, in the law laid down by the Supreme Court of India in the case of Lily Thomas. This will be Lily Thomas versus Union of India.
Into. ये लोग बिगड़े हैं पैराग्राफ्स पैराग्राफ में बिगड़े हैं लेटर said this one, accordingly, paragraph 54 of the case of Lily Thomas with the Mega Super is quoted below. Next paragraph. Accordingly, the review petition is the second review petition stands dismissed. Next, the consequences of the hearing before referred opinion dated 1/2/2011 passed by the Foreigners Tribunal number 1, Dhubri in FT case number 530/SSM/2010 within bracket reference case number 1599/98 page 54 shall follow. Next paragraph, the standing counsel for the for the foreigners and active matters is border and active matters is directed to send a download copy of this order to the government political within bracket B department for their record. Next paragraph, the registry shall also communicate download copy of this order to the said tribunal to be made a part of the record of the said FT case number 530/SSM/2010.
I dispose of books.
Just take a short break and come back. Look.
I dispose of books.
Just to dispose of.
In view of the disposal of the review petition, the IA may be closed.
This order will come in IA because the review is not yet effective.
Right.
It will be tagged, when it is released. Since we have control the delay, it will not be released. How did you extend the point? It will be a common order.
No.
Also, may I have also involvement in this issue? In fact, in either before, when the matter was called, I was not present because I was present for a meeting. So in that the matter of the lots of question for day after tomorrow, very fine, I will have my instruction, but my absence may not.
This is below for pollution control. Water logging.
Water logging and lot of traffic now.
Huh?
Traffic also.
I think okay, we, what your name? It's a very down to be standard.
For hearing, item 8 with item 9.
May it please the lordship. Also, in this case, lordship, I'm challenging
Yes, yes.
the order of the court below the Coroner's Tribunal, lordship. The impugn order is at page number 13, lordship. The order is dated 19/12/2016. May I just read, lordship?
Yes.
His reference has been referred as by Superintendent of Police Border, MRG in short, SPB Demaji.
Read the entire thing.
Lordship. In next page, lordship, point of determination.
So just tell the points. If you start reading it, we will not be able to.
Just one paragraph, lordship, only one paragraph.
Yes, please continue.
The discussions and reasons. I have perused the written statement, evidence on oath, and exhibited documents on record that the proceedings purported father's name is Raman Ram Namasudra. The proceeding exhibited a registered sale slip in the name of his purported father, registered by deed number 23 dated 26/11/1966 in the office of the sub-register Ramakrishna Nagar of Kachar district as Exhibit A. A voter list in the year 1997 in his own name, Exhibit B. A link certificate issued by the Gaubura certifying Mukteswar Ramasudra is the son of Raman Ram Namasudra, Exhibit C. A certificate issued by the Siammukh Gaon Panchayat certifying Mukteswar Ramasudra is the son of Raman Namasudra, Exhibit D. The proceeding admitted that on evidence on oath that he was born in East Pakistan and entered in India at the age of 8 to 9 years old and came to Silapothar with his parents in the year 1972 and claimed that he is not a foreigner on cross. Now I shall discuss the documents which is exhibited on evidence, that is exhibit A, B, C, and D are not proved on record. Mere submission of documents are not admissible as evidence to determine the Indian citizenship for the proceeding. If I presume that the registered sale deed executed in the year 1966, which is more than 30 years old, in the name of proceeding's father, Raman Ram Namasudra, is true and admissible as evidence invoking Section 90 of the Indian Evidence Act, but he could not prove the Gaubura Exhibit C and Gaon Panchayat Exhibit D certificate issued on 4/11/2015 and 13/11/2016 on record to prove that he is the son of Raman Ram Namasudra. The voter list 1997 in his own name, Exhibit B, is post 24/3/1971 documents which is not relevant to decide the Indian citizenship of the proceeding. The referral authority in its reference has stated that the proceeding was born in Sylhet in Bangladesh under Jatiaganj police station and not disclose any documents to support documents in support of his Indian citizenship. From the above noted discussion, I am hesitant to believe that the proceeding is an Indian citizen, and so in my considered opinion is that the proceeding is a foreigner illegal immigrant who came to Assam on or after 25/3/1971, and this order is passed in favor of the Assam state of Assam. Now, Lordship, if Lordship peruses the Exhibit C and D, I have marked it as green tag in the LCR, Lordship. Page number 52, 61, and 65.
Yes.
So these are original documents, my lord.
But you know why, you're aware why this can't be looked into?
Lordship.
It contains the state emblem. Will be, and you don't think that the authors were called for an examination?
Yes, Lordship, they were not called for examination. That is my case, Lordship. If an opportunity be granted to me to do that exercise, Lordship.
And has to be covered by the prescription of order 23, order 41 to 23 or 23A. Demand cannot be to fill up a gap in the evidence.
Well, in that regard, I have a judgment to place, Lordship, if Lordship may look into it. Lordship.
And you have not produced the refugee certificate.
No, I have not have. It has not been there in the record. I have not seen that. Now, para number 11, Lordship. The last portion, almost the same facts, Lordship. The voter list of 1997 indicates that the age of Asaq Ali is 58, while the petitioner was 24 years old. In the voter list dated 1966, the father of Asaq Ali has been shown as Kamad Ali, and Asaq Ali's age has been shown as 28 years. In view of the above, without entering into the question regarding correctness, genuineness of the said documents, we find no difficulty in holding that the petitioner had submitted some relevant document in support of his claim. However, as pleaded by the appellant, due to his illiteracy and ignorance, he has failed to prove the said documents in support of his claim. Therefore, it is not a case of the appellant that no documents in support of his claim. Admittedly, he has failed to prove the said documents. Considering the fact that the petitioner has stated that due to his illiteracy and ignorance and on bona fide belief he failed to prove the said documents in support of the claim of the citizenship, which is a valuable right to the petitioner, we are of a considered opinion that for the ends of justice an opportunity should be granted to him to given to him to substantiate his claim. If such opportunity is given to the petitioner, no prejudice would be caused to the respondents. Rather, granting such opportunity would meet the ends of justice, and the appellant also will not feel that he has been deprived of the deprived from establishing his valuable right with regard to his citizenship. Therefore, the court is of the considered opinion that to meet the ends of justice, the impugned orders are required to be set aside, and the appellant should be given an opportunity to substantiate his claim. Now, Lordship, all I am submitting, Lordship, is that the documents which has been there, which I have placed, Lordship, that it may not be very sufficient, Lordship. I also understand that, Lordship. But an opportunity may be granted, Lordship.
Yes, Mr. Sharma. This is the LCR. You want to say this? Okay. Please put on your speaker. We are missing our voice.
Yes, Lordship.
We are here under certiorari jurisdiction, Lordship, and we are only to see whether the opinion of the tribunal is good or bad, Lordship. And my humble submission is that there is no infirmity in the opinion passed by the learned tribunal, and Lordship, if Gaubura's certificate goes, Gaubonsa's certificate goes, Lordship, nothing will remain, Lordship. Gaubura's certificate contains state emblem, Lordship. Already, Lordship, law has been settled in this regard, Lordship. If document itself is not admissible in evidence, then question of remand back is not arise to prove this document, Lordship. And Lordship, otherwise, Lordship, in second case, Lordship, I have no record, Lordship, so in case of second case, Lordship,
Second case, you have not heard.
Yes, yes.
I will take up.
Otherwise, Lordship, my humble submission is that there is no link at all, Lordship, and tribunal has done nothing wrong by passing the impugned opinion, Lordship. That's all, Lordship. So regarding
Which year is your first voters list?
Your first voters list is
1997.
1997.
As per the record I have not.
It's okay. Which page is that?
Lordship, annexure 1, Lordship. Page number 9. In SMS is page number 10. And my name is reflected as Ramon Ram. My father's name. Lordship. And Lordship, my father's name has been presumed to be true by the tribunal under section 90 of the Evidence Act. Lordship. This is wrong. See, this is a document. You get the remark at your hand. Where your hand is. Right side.
Yes, Sri Raman Ram Namasudra, son of late Boikuntha Ram Namasudra, yeah, Jamrail Zakiganj, Sylhet, now Bangladesh, came to India on 28/9/1964 with three defendants as mentioned in column 3 of the application. They entered their name in the refugee identity card registered 1964 by the entry number so and so. Yes. Yes. In column 3 lordship, proceedings name was there.
Because they knew how to.
Yes, lordship, it's two lordship, but
They had to
lordship.
assist us.
I didn't see this letter.
That's why we look at the record, we see it very carefully. Is there then
Yes, it's lordship, it is there.
we're trying
Uh,
section 3 of the
only,
description of it.
only, yes, sir. It will go back lordship.
Has to be 100. My lord, what we are proposing to do is that this, so far as your repetition is concerned, we'll be compelled to dismiss it. Because once Mr. Sharma reminds us of the statutory jurisdiction, then it is not for us to substitute the view of the tribunal. But you get a benefit under the Immigration Act of 1950. On your prayer, we permit you to explore that possibility, and therefore we intend to grant you bail for a period of 3 months by the Superintendent of Police border. If you can move the authorities, well and good. Otherwise, the opinion will take its.
Well, that is acceptable to me, but only thing, may I just, in the three bench judgment, Lordship, in the Muslim Ali case, Muslim case also, in pair number 112, Lordship, there has been categorically, it has been held in statutory jurisdiction also, Lordship can interfere and like Lordship.
Oh,
All I'm reminding.
There are Supreme Court judgments which impliedly overrules even the full bench of this court. What does Vikarpin Das say?
I just pointed out, Lordship.
No, we are conscious about it. Statutory, not even that, there is a constitutional bench judgment of the Supreme Court referring to the powers under statutory. So the full bench never referred that. So therefore, it would be, so far as that observation is concerned, would be parental. There's a full constitutional bench as well. Constantly. But okay, there's one, we'll continue after the after a special bench at 2 o'clock. After that, we'll continue because we are almost out of time.
So 3 o'clock, Lordship, 3:15, Lordship.
We don't know, after there's a special bench at 2 o'clock, after that only. Yes,
Lord, item number 12 to 15, it is fixed for hearing. Your Lordship, we are under the impression that your Lordship would rise at 1 o'clock. So, may I pray that these items may be taken up on 27th of August. My friend appears for the opposite parties, Mala. Thursday.
no, this bench will continue after the special bench.
My lord, I pray, my lord, because I thought that this bench will not sit in the second half. I'm leaving for Calcutta today, in the evening, my lord. Kindly accommodate us for today, my lord.
Item number?
12 to 15, my learned friend, Mr. Hawk appears for the contesting parties.
Inform the other side.
Yes, ma'am, he's here.
I'm here, Lord.
He's here, my lord. My friend is here.
Is a representative, and if they are made by Mr. B.D. Kumar and senior counsel for the apparent in WA 159 of 2024. Mr. John today. This term. When?
27th, my lord, Thursday. Yes, sir, those matters relating to Borketry College, madam. We are obliged, madam.
May it please your lordship. My lord, before start, my lord, I'll just point out one thing before your lordship. In their affidavit, if you have gone for their affidavit, my lord, in their affidavit, my lord, they have very categorically, they have taken a plea. Your lordship, kindly see their affidavit, my lord, para 13, my lord. Affidavit filed by the, my lord, Mr. Goswami, my lord. 22 there. Because their defense, they have taken that he is at that point of time has a mental illness, he is psychiatric patient, he is taking medicine, and everything is, my lord, your lordship kindly see that para 13, my lord, what they have stated.
So, my lord, in under that your situation on your lordship, kindly see section 22 of the my lord BNSS. 22. Sorry. BNS. No, recon. Assessment my con. Yes, my lord. No, it's 22 to 8 worship.
No, not mental health act.
Section 22.
Correct.
Health BNS. BNS.
Healthcare.
এই নতুন খনৰ নাহেও একো নাহে
Mental Healthcare Act.
No, my lord. Act of a person
So
unsound.
you're on which act?
BNS.
BNS. Okay.
Again, my lord, you have to go to the BNSS also, but your lordship kindly see my lord for the timing, section 22, my lord.
Yes.
So, since he's pleased that unsound mind, then my lord, procedure laid down in my lord 367 of by BNSS, my lord. That procedure, in that case, what procedure will adopt? That is my lord BNSS 367. Why I am submitting, my lord, in such a situation, my lord, one, your lordship kindly see, my lord, one.
No, that we don't find this to be considered. This is for two reasons. Number one, and he does not say that he is a person with unsound mind.
But he is pleased,
He's pleased that at that point of time it was taken.
my lord.
So that is a defense.
There's a defense.
Plea of
So
defense.
why I am submitting, I have come as a judgment. Your lordship kindly
Plea of
see, that was the
defense
plea,
will be what in a manner which Mr. Chaudhary chooses.
and that is my first plea, my lord. Second plea I will come. Two copy this, my lord, only one page judgment, my lord.
Yes.
Because he has taken that plea here he has taken that plea, my lord. He has taken para 13 clearly, my lord, he has taken that plea. That I, at that point of time, I was so and so, so and so. So that question arises before our honorable apex court, my lord. Because that was not allowed to taken because, my lord, he was not taken in the WS, my lord. The initial stage, it was not taken. That's why it was disallowed, my lord. But here in this case, he has taken this plea, my lord. That's why I'm pointing out, my lord.
Where is this plea?
My lord, that para
Taking the plea.
12, para 13.
It. No, this can't be. The posts were made at the moment of utmost mental distress and medical impairment. This is not insanity. And
My lord.
And
No, it's, I pointed out.
the second part is that under the Mental Health Care Act, it is impermissible for the court to have us make a suggestion that he is of unsound mind. That plea will have to be taken by the person himself.
And then as per the act, he has to take his own decision as to what is to be done. In a criminal proceedings, the plea of insanity is something which the court, in its own motion also, can perceive from the manner and demeanor of the person and ask for a medical evaluation. So this plea is not a plea of insanity.
They're not like melody, since they have taken this plea.
No, but there is another aspect which you will have to
Not
address.
that fair, my lord. Your lordship kindly see.
No, but there is another aspect. You forget about the defense taken. What is your case in your evidence?
No, my lord, and my second prayer is that, my lord, I may be allowed to, my lord, file an additional affidavit, my lord, to bring certain things to record, my lord. But because that was which I missed out in my earlier affidavit, my lord. So that's why I paid for, my lord, some time to, my lord, file this affidavit, my lord. In fact, I drafted
No, additional evidence.
my lord, to bring out some.
No. Just a moment.
Taking into account that we are dealing with a case where the examination in chief is given by a judicial officer.
My lord,
And the judicial officer is not aware of that in fact, if we go as per this, there's no case made out for criminal contempt.
that's why I do apology, my lord, I mean, here.
No, the question is, there is no criminal contempt made out because unless the document is not proved, he may very say that they have mentioned about that particular document in that he has given the Facebook contents out there, he has said that he has given. But the fact remains that the contents of the document has to be proved by the document.
Correct, my lord, that's why, my lord, I very
And
pardon.
it's surprisingly that you have filed it in this manner.
Being on record, my lord, your lordship kindly give me one chance, my lord. So that, my lord, in process, there should not be any lacuna.
I think we
But
should impose a cost upon the
No, that's my lord.
because we fixed the matter today, taking into account that we have other matters. My
Correct.
brother Surana has some matters out there, and I also have some other benches out to take note of. We have specifically fixed the matter today on account that everything will be done, the cross-examination will be done, and we can proceed with it. But this doesn't seem to be in here. Anyway,
Anyway, my lord, please, my lord, you should not, my lord, be prejudiced, my lord.
what do you say, Mr. Chaudhary?
Yes, my lord, but I came prepared.
Yes. No, the moment you put
Correct.
one
And your
question,
lordship has
the entire,
rightly pointed out.
the entire foundation of the case goes. One question. You don't need many more. Only one question. Where is the document? Remaining are nothing. Remaining will be just hearsay about some other judicial officers or something to the effect that this particular, the accused out here has informed me in the court that he is going to go to the High Court against these orders and whatnot. But the main part was the
My lord,
Facebook post. The Facebook post which was originally there and the Facebook post which was subsequently. Merely writing, can there be an oral evidence of a document?
give me some list, my lord.
But we intend to
Because
impose,
in
token
that
cost.
case, my lord, certificate, no.
But we intend to impose a token cost.
Yeah, my lord, I think it will be.
But the bench is collapsed. Insofar as,
It doesn't seem the High Court have taken it very seriously, this matter. You have to understand if it was the first offense where we have not imposed any penalty upon him or any conviction upon him. Now his conviction is under suspension for a
Yes,
period of 4
very-
years. We have to be very serious on this. The moment you don't do this, then why should we? Because the moment, if there is no case out here, the matter is over, then obviously he has still a suspended conviction. Because this is a very serious thing. Therefore, we are taking it each step we are taking it properly. So that it doesn't happen, there should not be anything, so that the moment we give anything on this conviction, his conviction which is suspended revives. This seriousness has to be there from the High Court.
we intend to impose some cost. It will be token, but we will impose.
It will be a stigma on her, my lord, that will not be,
Hmm?
it will be, my lord, because I pay apology, my lord, on that.
No, but you also settle it. An affidavit just does not come without being settled, without being approved by you. That is why we are more concerned.
My lord.
Though the officer is present and we are not examining her, but the fact remains that the evidence is incomplete.
As a last chance, my lord, your lordship kindly, I beg apology, my lord.
No, apology for your settlement or for
Settlement, my lord.
the lacking in the evidence. But be cautious because it calls, it tells upon both the witness and as well as
I know,
calls
my
back
lord.
on you.
I know because in my initial days of my career, I have facing this, my lord. Actually, I really know that the reported case. And more importantly, we are in a court, my lord. Both the honorable judges has lot of exposure on both sides. A little bit, not little bit.
My brother is a vast, what do you call,
Both of you have.
working knowledge. Okay. But, please, Mr. Chaudhary, please suggest a date because your convenience and because
My
the.
lord, in that case, can I pray sometimes in September, my lord?
You have filed a petition, I suppose.
It's fully ready, my lord, but
You have not filed that petition also.
no, it's not really ready, but because paucity of time it will be difficult, man.
You should have filed the petition. This is a criminal contempt.
During the course of the day, I'll file, madam. Because the process is required.
Orally things won't work here. Has to be by way of a petition.
Then, madam, you
because that has to-
have to give me time to file this petition, because I have already
No.
drafted and my junior has already signed it, ballot. It is.
It's okay.
It is,
We
because
will-
it is, has to be signed,
We
madam.
will pass the order in that application.
Madam.
In
My
that
lord.
petition, we will pass that
I-
order
yes, madam.
later on, giving you the time, when can you file your application? Your additional affidavit, it is more like a further evidence.
Madam,
When are you going to file it?
within 2 days, madam.
Huh?
Within 2 days. Two,
Are you
3 days.
sure?
No, he will be, I. No, September first.
Because you need, I may not suggest, but I'm just mentioning it. This is an electronic evidence.
Madam,
You have to do so in terms
Certainly.
with the PSA.
as for the evidence.
The certificate is not the same certificate
My
like
lord.
65B, but there is a difference in the certificate.
Certificate in our.
So these are things which are required. It will be possible to do so within 2 weeks.
Within a week, madam, I hope, 1 week. Huh? Certificate.
You must identify the instruments,
Yes.
the computers, everything. You have to maintain that chain. It would require again hashtags to be seen.
That will. I hope that is one.
1 week.
1 week.
Okay, and this application for adjournment?
You file it.
During,
pass that order.
during the course of time.
In course of the day, you are filing it.
Madam. Already the head sent it for getting, because it is the assigned matter, the study edition.
So do it, because we'll pass orders, otherwise if the application doesn't reach us by a rising time, then it will be difficult. Because this is a criminal proceeding, we'll have to
My lord, I
file
understand.
an,
No, already, because it is in process, madam. It's already. Some time is better. Okay.
so,
Yes, that's only when it would be convenient for you to file the cross-examine, because the next stage will be for cross-examine.
Yes, yes, my lord. Once they file, only thing is, my lord, this month there is some difficulty, but it will be in the first week.
just check your calendar and tell us the date, then we'll.
7th or 9th, my lord.
9 not possible.
Okay.
You have to have it on 10 for 10.
Then,
There's no special bench on 10. Okay,
it can be kept at 2 PM, my lord, or, yeah, yes.
2 PM. 10 o'clock, tentatively 2
Basically, it
PM.
will be for cross-examination, my lord, after whatever they find.
Yes, but we will pass orders if the application comes.
My lord.
You give a requisition to the court master in the meantime. You file it and we'll get it, because we'll pass orders there. Please bring it. Mr. Chaudhary, we'll pass orders in the chambers when this
My lord,
application comes. So the next date will be 10th. So the date.
and it's been an other adversarial litigation, I would have objected to so many things. And it is because of the peculiarity, my lord, I'm not even raising my objection.
It's okay.
Mm, okay.